Hello and welcome to Fact Friday. Today is August 7th, 2026, and I say welcome back, unfortunately. It's been a while. Several people have asked why we stopped making these videos, and really the answer is simple. The drama and toxicity had settled. The community wanted to move forward, and so did we. So here's a little history of Fact Friday. We started these episodes back in March of 2025. There were 11 episodes that ran over 10 months, and they covered issues that related to CBA, POA. In fact, the first episode was quite a long one because it debunked many of the misrepresentations and deceptions that were made by Rahm and Harrell in their official capacity as CBA, POA board members during that time. Like I said, 11 episodes, 10 months, but we stopped doing Fact Fridays in January 2026. The lawsuit came to an end, and in an effort to support the community moving forward, we just didn't want to add to any drama. And then August 1st, 2026, that was the last board meeting, and that board meeting video is up on YouTube now. The drama and the toxicity returned. Not from the actual board. The board business took about 13 minutes. It ran nice, quick, smooth, but it was in the member comments, and it was the toxicity twins, Rahm and Harrell. So today, Fact Friday returns. Several serious allegations were made publicly against myself, my family, my friends. Because they were made in a public forum and actually involve allegations of criminal activity, I felt a public response with facts is highly appropriate. The first half of the meeting was refreshingly ordinary, short, sweet, to the point. Took about 13 minutes. It involved treasurer report, road report, bylaws committee discussion, a discussion about a possible community fish fry or a neighborhood garage sale. Roads, finances, insurance, volunteers, a possible fish fry. One resident complimented the roads, saying that they were in the best condition that they've seen in nearly 20 years. The meeting was routine, productive, the way meetings are supposed to go. Then came member comments. And here's what happened next. So the code of conduct was read aloud at the beginning of the meeting, as it is at every meeting that this board has been presiding over. And that code of conduct includes a strict prohibition on personal attacks. Honestly, we saw enough of those in the last couple years. Once the member comments portion of the meeting was opened up, Kelle immediately launched a series of allegations against myself, my husband Mike Harris, my mom Kay Sullivan, and my dad Jerry Sullivan, made publicly on the record. Even one snide insinuation was made against Charlene, which is provably false, and there is a slide coming up at the end of this presentation that shows what Rahm stated is provably false. So Kelle just can't help themselves, can they? They broke the code of conduct in the process by indulging in personal attacks. Harrell stated that the airing of these grievances was board business, since she claimed harassment, cyberbullying, etc. were occurring. She claimed the board failed in its duties to respond to her allegations. But let's just take a pause here. Is this board business? What the harassment, cyberbullying, etc. she's claiming are crimes. If a crime is committed, the proper authority is law enforcement. It's not the duty of the board to police the community or to investigate crimes. That is what law enforcement exists for. And I'm sure if they had ever contacted them, they would reiterate to them that criticism does not constitute harassment. So I'm not going to play all of Kelle and Kelly's rants. The board meeting is recorded. It's on YouTube. You can just go look and listen to the whole thing if you want to. But I just wanted to point out an area here. Harrell, she went off on a bunch of different tangents, but this one is very relevant because she actually states that certain actions are, crimes under Texas law. So let's take a listen to this.
Their conduct includes but not limited to confronting homeowners and their families in common areas or private properties to harass, intimidate, or threaten them, using digital platforms including Facebook, YouTube, email, and X to disseminate false statements, baseless accusations, and hostile commentary intended to damage reputations, humiliate residents, and inflict emotional distress. Their actions meet the statutory definition of harassment and cyberbullying under Texas law.
Okay, so first, to disseminate false statements, everybody knows my email address. It's here on YouTube. If I make a mistake, if I make an error, let me know. I will correct it. But I have yet to receive one request for correction ever. Baseless accusations, yeah. Anybody that's been watching Fact Friday knows that I lay out the facts, I lay out the recordings, I lay out the documents, I let you guys make up your own decision. Hostile commentary intended to damage yada, yada, yada. Okay. The big thing here is at the end. Their actions meet the statutory definition of harassment and cyberbullying under Texas law. And boy, this is familiar when our former paralegal likes to trot out what's legal, what's not legal in her interpretations of the law. Okay, so there were basically 6 major themes of claims between Kelle Harrell and Kelle Rahm at the meeting. Harassment and cyberbullying, which we were told is against Texas law, intimidation, intentional infliction of emotional distress, breach of fiduciary duty, and let's not forget forgery, which would be a felony. So let's do what Fact Friday has always done. Let's compare the claim with the evidence. Okay, so circling back to claim number 1 and 2, where Kelle Harrell stated that their actions meet the statutory definition of harassment and cyberbullying under Texas law. That is a direct quote from Mrs. Harrell in an open board meeting at our POA. Notice something. This wasn't simply saying, I felt harassed. This was a specific claim about Texas law, a legal conclusion, not a personal feeling. So, let's read Texas law. There are several elements for the crime that is termed harassment in Texas Code. So Texas Penal Code, Chapter 42, Section 07, sets the specific requirements for conduct to qualify as criminal harassment. The first element is intent. The accused must have the intent to harass, annoy, alarm, abuse, torment, or embarrass the other person. It's a good thing that there's more elements because I can't imagine how many people would be up on harassment charges if every time they annoyed somebody, they got hauled in by the sheriff's office. So, as I've stated before, our intent is to correct misstatements, false information, deceptions that have occurred in the past. You can see that we were perfectly fine with not doing Fact Friday for quite a while until, yet again, false statements, false accusations, and just belligerent nonsense showed its face. And so our intent is to educate, inform, and to set the record straight. Here is the second element for the crime that's called harassment in the Texas Penal Code. And that is that there are required conduct to be demonstrated. Specific enumerated acts are required, not just general statements or public commentary. And criticism does not equal harassment. So what I'm pulling over here onto the screen is, see the statutes.capitol.texas.gov up there. You can find all Texas laws there. So I went there and I went to Penal Code, Chapter 42, Section 7, harassment. A person commits an offense if, with intent to harass, annoy, alarm, abuse, torment, or embarrass another, the person initiates communication and in the course of the communication makes a comment, request, suggestion, or a proposal that is obscene. Nope, that doesn't apply. Threatens in a manner reasonably likely to alarm the person receiving the threat, to inflict bodily injury on the person, or to commit a felony against the person, a member of the person's family or household, or the person's property. Nope. Number 3, conveys in a manner reasonably likely to alarm the person receiving the report, a false report, which is known by the conveyor to be false, that another person has suffered death or serious bodily injury. Nope. causes the telephone of another to ring repeatedly or makes repeated telephone communications anonymously or in a manner reasonably likely to harass, annoy, alarm, abuse, torment, embarrass, or offend another. Nope. Makes a telephone call and intentionally fails to hang up or disengage the connection. Nope. Knowingly permits a telephone under the person's control to be used by another to commit an offense under this section. Nope. Sends repeated electronic communications in a manner reasonably likely to harass, annoy, alarm, abuse, torment, embarrass, or offend another. And by the way, this is not posting to Facebook when you're not a member. This is actually sending out text messages or instant messages or something directly to the person. Publishes on an internet website, including a social media platform, repeated electronic communications in a manner reasonably likely to cause emotional distress, abuse, or torment to another person, unless the communications are made in connection with a matter of public concern. And so I'm just going to highlight that there for a second because, it's not my fault if the truth coming out felt like embarrassment to them, or if it felt like torment or distress, emotional distress because the truth came out. Not my fault. And this little thing here, the communications are made in connection with a matter of public concern. I'm going to bring that up because that is actually defined in Texas law. What is a matter of public concern? Okay, so I scroll down and it says, in this section, matter of public concern has the meaning assigned by section 27.001 Civil Practice and Remedies Code, which I'm going to go on over here. Civil Practice and Remedies Code, Chapter 27. Definition, matter of public concern. See, I'm right here. Matter of public concern means a statement or activity regarding a public official, public figure, or other person who has drawn substantial public attention due to the person's official acts, fame, notoriety, or celebrity. Probably doesn't fit here. They're not near as famous or as relevant as they think they are. B, a matter of political, social, or other interest to the community. Well, yeah, that fits because POA, they say all politics is local. The POA is as local as you can get. Its elections are regulated by law, by Texas law. The board serves with fiduciary responsibilities. People on the board are public officials to those within the community that they serve. So, okay, it was a matter of public concern, which means even if it caused torment or distress or emotional anguish or torture or whatever to the people that I was criticizing, it doesn't matter. It was a matter of public concern. Okay, back to the statute on harassment. So I explained this publishes on internet website, including a social media, yada, 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 yada. Yeah, matter of public concern makes that not a valid point. Tracks or monitors the personal property or motor vehicle of another person without the other person's effective consent, including by using a tracking application on the person's personal electronic device or using a tracking device, or physically following the other person or causing any person to physically follow the other person. So there's going to be a little bit of a discussion here because Mike did get into it with Cody. Mike was on his way back from the church where he had mowed, and he had a bunch of weed eater, mower, all that stuff in the back of the Ranger. And as he was coming into the neighborhood, he saw that the sign had some high weeds around it. So he got out and he was trimming the weeds when Cody came up. And actually, Cody has shared this video with some people where he's mumbling that Mike has no business being here. He has no business being on this property. So just to clarify, that is the county road right away where the POA's bulletin board and sign is. And Mike was just trimming the weeds. So Cody comes up all full of bluster and all that other stuff. According to the story I've heard, and I believe it. And actually, Mike has some cell phone video. It's all over the place because his phone was moving around. But so anyways, Mike, he's been through a lot with Cody over the last 18 months, 2 years or so, and he made fun of him. He's coming out there all full of bluster because Mike is on his property and it is his sign and all this other. And Mike made fun of him, said he heard that he had lost his property because it was quit claimed deeded back to his mama for $1, which is seen on the Trinity County Appraisal District. That's not confidential information. He originally got the property for $1 from mama, and it went back to mama for $1. So Mike was making a little fun of him with that. Said, "Don't worry, Cody. The community will pull together. We're going to chip in and buy you a tent, buddy." That kind of thing. So there was, verbal altercation. They're yelling at each other. Cody leaves. Cody comes back with a zero-turn lawnmower and starts making aggressive movements towards Mike with the zero-turn lawnmower, and actually damaged the weed eater that Mike had. Luckily, he didn't damage Mike, so there's always a positive there. This altercation finished, and Cody goes back to his place, and on the video that he has shared with some people, he's talking about how he put gasoline on the road to prevent anybody from coming down Lakeside Circle, etc., etc., etc. But anyways, Cody goes home. Mike gets back in the truck. He's done weed eating. He's about ready to go home, but on his original list of tasks was to run up and down the different roads and make basically a road assessment. Look for problems within the POA, problems with roads, etc., etc. So that would be, I don't know, maybe once or twice a year, he drives up and down all the roads and just takes a look and makes notes, shares them with Dad. And so he thought, I'm already up here. I'm just going to go ahead and make a quick circle. So, it is my understanding that that is now being confabulated into Mike is stalking Cody. If they check their security cameras, they'll see that that was the only time this year that Mike has been down Lakeside Circle. And he just wanted to get that over with. He was gonna go up and down the other roads and continue his road survey, but then he saw Cody was chasing him. And he didn't want to lead Cody onto anybody else's roadway or property or anything else, because he is not somebody that appears to be very stable. So, yes, there was an altercation, and that is basically the foundation of this whole spiel by Kelle Harrell at the meeting that our family is harassing her poor innocent son who never does anything wrong. They're just targets, they're victims, etc., etc., etc. So there's many of us in this neighborhood that are fully aware of Cody and Cody's behavioral tendencies. So I'll leave it at that, and people can make their own conclusions. If you were trying to figure out who was being aggressive and making intimidating moves towards somebody else, who do you think that was that day? So that was for number 9, tracks or monitors the personal property or motor vehicle of another. Harrell, in another missive, had stated that basically we were surveilling her or her son or something like that. There is some kind of word about surveillance, that we're following people or something along that line. Whatever that is, because I didn't get a copy of it. It wasn't emailed to me by Miss Harrell. But my understanding is there's some kind of accusation that we are surveilling or have put trackers or something. I don't know. So let's move forward. All right, so we have eliminated intent, required conduct, and then this one I just went ahead and made green because public concern exception. Yeah, that applies. So of the 3 there, we seem to be in good shape, and criticism does not equal harassment. Okay, so let's move on to claim number 2, cyberbullying. What does Texas law actually state about cyberbullying in the context of adult interactions? Yeah, sometimes it's just good to have a little humor with it because there is nothing about. So what I have pulled up here now is the statutes.capital.texas, like we talked about before. All laws in Texas are listed here. And you can go to the search tab and type in cyber. I typed in cyberbullying. Here is what we got for results. This area down here, you can see the links to particular statutes that are relevant. The first one is Civil Practice and Remedies Code, Chapter 129A, Relief for Cyberbullying of Child. Now notice it says child, it doesn't say man-child, but I could see where maybe Kelle Harrell got this a little confused. These cyberbullying, the only statute in here that's outside of a school district code is cyberbullying of a child. Miss Harrell, if your child is socially or mentally delayed and you would like the board to make special accommodations for him, I think you should send a letter with documentation to the board. So claim number 2, cyberbullying. What the law actually covers is only in the context of children. For disputes between adults, different statutes regarding harassment may apply, depending upon the specific facts of the situation. And spoiler alert, criticism does not equal harassment. Now, why this matters. There is no general standalone criminal offense simply called cyberbullying for adult-to-adult disputes in Texas. Using legal labels loosely without citing the specific statute is shoddy legal work, even for a supposed former paralegal. Claiming crimes to justify personal attacks at a board meeting? Well, that's just pathetic. Okay, so let's count the claims. Harassment, cyberbullying, we've already debunked those. Intimidation, intentional infliction of emotional distress. Well, the thing about these two is they're not actually crimes, they're elements of crimes. If anybody feels that they are being intimidated, harassed, etc., and it's a criminal act, call the cops. They will explain what does and does not constitute harassment. Okay, the 5th claim is breach of fiduciary duty. It was a complaint against Jerry Sullivan as chair, Mike Harris as a board member. Said that they breached fiduciary duty. And for those who are unaware, there is a whole Fact Friday on fiduciary duties, what they are, and how the previous board under Kelle and Kelle had broken every one of them. But just in general, it's a duty of loyalty, which means that you put the community's needs first and don't use the role for personal gain. Duty of care, making careful, thoughtful choices and acting with competence. Separating funds, never mixing the POA's money with your own. Keeping records, saving receipts, bills, transaction notes, etc. Oh, and Miss Kelly Rahm, you might want to be paying attention to that. Saving receipts, bills, official things that were filed with the county clerk's office, all that. You know, it's one of those things, if you want reimbursement, you need to follow the process because we are a nonprofit association, and as such, records have to be kept. And then following instructions. So that's obeying the limits written in the POA document, Texas Property Code, the Unincorporated Nonprofit Association Act, following those limitations and instructions. Okay, that's fiduciary responsibilities. The board does not have a duty to investigate crimes between individuals within the community. That's what law enforcement is for. And thank goodness, can you imagine if POAs with a bunch of, I don't even know what to call it. We've all seen or been in POAs that have a bunch of people that just have their nose in everybody else's business. Can you imagine if they thought they were law enforcement and could, like, start investigating what they consider crimes and everything? No, that's what law enforcement is for. We have constable and we have sheriff's deputies out here. In the absence of misconduct, exactly what fiduciary duty do they think that Dad has broken? I guess maybe loyalty. They're saying that he's putting his family above the community, and it's like, no, his family is for the community. It's all good. So anyways, there was a verbal confrontation between a board member and the son of a property owner that did not involve board business, and it's not board business, and it didn't lead to the notification of law enforcement, and adults should be able to handle conflict themselves, or if a line is crossed, notify law enforcement. I don't know what's so complicated about that. So, all right. That was the fifth claim, breach of fiduciary duty. So now we're going to come to number 6. But forgery. Forgery, they say. Yeah. Okay, so I've been hesitant to talk about this because this just takes things to a whole other level. An allegation was made by Kelle Rahm. She stated that me and Mike had refused to cooperate with law enforcement. And there's been all these little insinuations, and Cody's whispered at me in board meetings that I'm going to go to jail for forgery. And Kelle has actually made that accusation against numerous other people, but she seems to focus on Mike and me about this. So here's the timeline. So back in March of 2025, if you remember, we were putting pressure on Kelle and Kelle to please shut down the corporation that they had formed without authorization. Its presence was harming our association. It shattered our credit report. It creates confusion with vendors, etc. The corporation was not authorized. It was a separate legal entity from our association, operating under the association's name. So let's pause for a second and listen to Kelle at the March meeting where she had printed off this form that later was turned in to the Secretary of State and was trying to figure out how to fill it out.
Board members want to speak? I did get the certificate of termination from the state of Texas, and in order to do so, the event requiring wind up, there you have to check one of them. A voluntary decision to wind up the entity has been approved in a manner required by the Texas
Okay, and that was Paola Canaday's cell phone ringer. I'm sorry. Apparently it repeats sex a number of times.
Sorry. And the governing documents, a period of duration specified in the governing documents of the entity has expired. An occurrence of an event specified in the governing documents, and we shot down the thing to add that sentence. The occurrence of an event specified by the Texas Business Organization Code that requires the winding up or a court decree. Those are the 5 things. And so we have to pick one.
All right. And then discussion continues, and you can look at it. You can listen to this. I put the timestamp on this slide. It was at 1 hour, 58 minutes into the March 1st, 2025 meeting. But my point is she came with the forms trying to figure out how to fill them out March 1st. March 26 is apparently the incident where the form was received by the Texas Secretary of State to close the unauthorized corporation that Kelle Rahm claims that she did not sign that document. So fast forward from March to November, that is what, 8 months? 8 months later, a deputy came to Camp Branch Acres and started asking for different individuals to simulate a forgery as what he was calling a voluntary handwriting sample. He was asking for them to sign Kelle Rahm's name as if they were forging that document, which is a really unorthodox thing to ask for, and it actually does not fit under the category handwriting sample. It falls under the title forgery simulation or testifying. Considering that it's really unorthodox, after some of the people that I know here had turned in samples to the deputy, we were having discussions. I was like, that doesn't sound right at all. And I did reach out to some people that I know that do document forensics, and they said, yeah, that won't stand up in any court of law. It can't rule you in. It can't rule you out. Like, they even doubt that Austin, the forensic lab, would even accept such samples. So that was in November. And then several more months went by until January. And that's right when the lawsuit was at its height. And the day or the day after that I filed a motion to impeach Kelly Rahm's testimony in our lawsuit, a deputy arrived in Camp Branch Acres again, and he left a business card on my front door because I wasn't available whenever he came by. So I reached out to him, and he asked for a voluntary handwriting sample. Well, I was already aware of the forgery simulation request that had happened with some of my neighbors and friends, and I wasn't inclined to do that. So I did communicate back with him that I would consult an attorney first. I'm not cooperating, but I have a constitutional right to consult an attorney before providing any kind of voluntary sample, and that's what I did. I consulted an attorney. I had several that I had been working with anyways. And the attorney that I consulted with said, yeah, absolutely. What was being asked is not at all correct, forensic wise. And the state, both the Secretary of State, the district court, and the Trinity Sheriff's County Office have samples of my handwriting, natural samples where I filled out paperwork, I signed paperwork, I filled out reports, different things like that. Honestly, if the state wants handwriting samples, there's quite a few of them with my handwriting all over it, both at the sheriff's office and at the district clerk's office. And then I guess Secretary of State was all digital stuff for me. So anyways, I consulted an attorney, and I reached back out to the deputy and said, I politely decline. However, if he wanted to follow up, I would do that with my attorney present. And for those who don't know, I'm a libertarian. I'm big on personal rights and the state not overstepping. And that's just something that I might have just like knee-jerk reaction provided the sample if it had been asked way back in November whenever they asked other people in the neighborhood for a sample. But I had had time to think about it, and I was like, this doesn't feel right. This doesn't feel legit. This doesn't feel like sound forensic practices. And whenever I consulted my attorney, that gut feeling was validated that this request was not reasonable and I should turn it down, which is what I did. So we sent the response, and it is now it's August of 2026. So a year and 5 months later since the original incident, and there's been no further follow-up. I think they were just checking the boxes of like, yeah, we asked some people, we sent some samples. But it's my understanding that the samples that they did collect back in November haven't been sent. Whether that's correct or not, that's what I've been told, is that no analysis has been done on any of this. And that would track with what my lawyer told me, which was that it's not standard forensic practice and is not evidence-based practice. So a voluntary request is by definition optional. Consulting an attorney before responding to any kind of law enforcement inquiry, voluntary or otherwise, is not obstruction. It is a right. So failing to cooperate with law enforcement is a gross overstatement of what happened here. If there was probable cause, I would be cooperating. But being asked to provide a voluntary sample, and then whenever I decline, nothing further happens. It seems pretty clear that I'm not actually a suspect. I've never been told that I am one. And let's just have a little straight talk here. What motive would I have? We spent considerable time and money to file our lawsuit in the district court, which even as a pro se person, the legal research, legal writing, legal counsel that I had, that even though they couldn't be there on court dates, they were expensive. There was considerable time and money in order to have that unauthorized corporation legally closed or legally invalidated. It would not benefit what Mike and I wanted to see to come of the situation, which is to have that unauthorized corporation just basically repudiated and gone. it wouldn't help anything to have a illegal closure. So whether Kelly Rahm signed it or not, that closure document, because the original board that started that corporation never voted to close the corporation, it was an illegal closure. Did not benefit us. However, it shouldn't have, but it did benefit Kelly and Kelly because they used the closure of the unauthorized corporation as a defense in our civil lawsuit, saying that it was a moot point because the corporation was already closed. Now, unfortunately, our judge was not a business law judge, and he even said at one point, I don't know if I've ever read all this business organizations code, Unfortunately, we had a judge that's definitely more familiar with the typical crimes in this county and Walker County. So, but the main point here still exists. Who would benefit? And this is speculation, but I would say that anybody involved in the lawsuit would benefit on the defendant's side because they could try to make the lawsuit go away, arguing that since the corporation is closed, the lawsuit has no merit, which is exactly what the defense did in our civil lawsuit. Or just to try to prevent the lawsuit in the first place, like back in March, they could file one of them or a family member of one of them could file the closure document just to make it go away, thinking that it would prevent them from being sued, but preserving Kelly Rahm's ability to say that she never did anything wrong. Because if you admit that you signed the closure document, then you're admitting that it was never legally formed and it shouldn't have existed in the first place. So let's just look at motives here. Who has the motive to close that unauthorized corporation? The people who are spending considerable time and money to have it legally closed, or the people who were trying to get out of being sued? And so in my communication with the deputy, I did send him some information about the possible motives of some of the people involved in the complaint. And I just kind of want to show you couple things. So here is certificate of fact. So as of December 9th, 2025, see here, the following documents were still being shown as true and correct by the Texas Secretary of State. And so one of those is actually the certificate of formation of the unauthorized corporation for May 28th, 2024 to the certificate of termination, which was dated March 26, 2025. So the Secretary of State does not in any way indicate, and I had to get these certified copies for the civil lawsuit. According to the Office of the Secretary of State, that filing is valid and legal, and it kind of indicates that while Kelly Rahm may have talked to the sheriff's office up here, did anybody inform the Secretary of State that that was not a legit filing? Because kind of hard to, I don't even understand how the sheriff's office is investigating a forgery when the recipient of the so-called forged document seems completely unaware, since they certified it as a true and correct copy and valid December 9th of 2025. And here is the form that Kelly Rahm says that she did not do. Certificate of termination of a domestic nonprofit corporation or cooperative association. Everything's typed in except you get down here and get down here and there's a signature. I want to make the point here that this is why I don't trust handwriting analysis, because let's take a look at this right here, Kelly Rahm's signature. Look how her K looks like a Y. The top of the K comes all the way down to the baseline. There's basically no bottom to the K, right? Well, what's really interesting is in our civil lawsuit, when the lawyer had stopped representing Kelly and Kelly, Mrs. Harrell filed a request to the judge as pro se defendants, and She signed her name. And look at that K. It's the same thing. The top goes all the way down to the baseline. There's basically no bottom to the K. This is why I don't trust handwriting analysis, because if somebody just logically looked at this, they would say, well, you know, who's probably most likely to have signed this is probably somebody whose K looked very, very similar. It would have been very easy to do. And that's why handwriting analysis is very unscientific. There are ways to get samples, natural samples, but to ask somebody to forge a simulation is just, that's not the normal forensic practice. But it is very interesting, and I had pointed it out to the deputy that there are people who have a motive for closing that corporation to try to prevent being sued or to try to close the lawsuit, who had motives and whose handwriting has some distinct characteristics that are very similar to the one that was submitted to the state, which, considering that the state doesn't even seem to understand that the people who filed it are saying that it's not them, it just leads to a lot of questions. And I can understand why basically it's how many months later? And I haven't been asked any further questions. So anyways, we're back to what Fact Friday has always done. We play recordings, show documents, cite statutes, and let the viewer decide. We don't ask you to believe us. We play the recordings, we show the document, we cite the statutes, then you decide. That hasn't changed since episode 1. And I guess what's important for the Harrells, or the Kellys, is criticism does not equal harassment, and truth does not equal libel or slander. So for the bigger picture, for months, this community has been healing. We've had board meetings that became routine. Volunteers have been out fixing the roads. We've had a couple really great little get-togethers. We had a crawfish boil. We had hot dogs on the 4th of July. It's been a nice neighborhood getting back to what it used to be. That's the Camp Brand Shakers most of us want. And there is one point of agreement with Miss Harrell and myself. Our community deserves professionalism. It deserves civility. It deserves respectful disagreement, which is what I try to do here. Facts, statutes, documents, audio clips, not me just spouting opinions. And our community also deserves decisions based on facts. Not allegations, not smears, not this, not that, whatever. On that, we fully agree. And so hopefully this is the last Fact Friday for a while, because when the drama and the misrepresentations and the deceptions disappear, so do we. We'd much rather spend our Saturdays talking about road improvements, fish fries, and neighbors helping neighbors. But if facts need checking, you know where to find us. Have a great Friday and a beautiful weekend, and watch the heat. The heat is high. Make sure you hydrate and give yourself rest if you're out there working on the land.